And welcome back. We're preparing to begin our first segment this morning, which will be a discussion on the Maritime Areas Act and, of course, the proposed amendments to that piece of legislation. That being said, we have with us Honorable, the Caribbean Shores Area Representative, Kareem Musa. Good morning.
Good morning, Isani, and good morning, Marlene. Thanks for having me on again.
Where do we begin from? Because the Maritime Areas Act is, at this point, a very critical part of going forward.
Yes, as you would recall, and I think you pointed to it earlier in the first segment of your show, it is important for us, as Isani, to look at the historical context of the Maritime Areas Bill and how it originated back in the year 1992, when the Right Honorable George Price was the Prime Minister of Belize, and the Honorable Said Musa was the Foreign Minister of Belize. What we did back then as a country is that we passed the Maritime Areas Act. Now, what was the reason behind the passage of the original Maritime Areas Act? If you would recall, back then it was President Elias Serrano, who was the president of Guatemala, and who many consider to be a close friend of Belize. Believe it or not, there was actually a Guatemalan president who was extremely friendly to Belize, so much so that the parties were able to come to an arrangement back then because the negotiations were live, they were well, it was looking very positive for a settlement between Belize and Guatemala in the year 1992. And so what Guatemala was asking out of good faith from Belize, because as you know, if you look at this map that is here on the screen, our map extends all the way down to the Sarstoon, and it cuts into the Sarstoon. And if you look at it, Guatemala is pretty much sea-locked, not landlocked, but sea-locked if it were that Belize were to claim its full rights under territorial international law, which is 12 miles from the baseline. So if you look at the Sarstoon down south, really speaking, if you jet it out into the sea, what we are legally entitled to as a country is 12 nautical miles. And so Guatemala, because their only access would have been down south, would have really been sea-locked to get into the high seas. And so what Belize did was we agreed to reduce our 12 miles to 3 miles just to accommodate a possible settlement with Guatemala. So we reduced it from 12 miles to 3 miles so as to allow Guatemala unimpeded access to the high seas. In return, President Elias Serrano, for the very first time on behalf of Guatemala, recognized the independence of our country. And this is very, very important. They recognized our independence in 1992. This is only 10 years after independence in 1981. And also they recognized our right to self-determination. Now, what the Maritime Areas Act also said back then was that if there was a settlement between the parties, now that we're on the path of peace. Now, I don't know, you guys look a lot younger than I am. I was only 13 years old at the time, but I can vividly recall the song, All We Are Saying Is Give Peace a Chance. That was the motto, that was the song. And truly, it was a bipartisan effort because you had Mr. Price and Mr. Musa on one side, and you had the Right Honorable Manuel Esquivel and the Honorable Dean Barrow on the other side. All of them going across this nation, town to town, district to district, actually going and meeting and consulting with the Belizean people on the Maritime Areas Act. And as you alluded to earlier in the first segment, it did cause a fracture in the United Democratic Party because back then it was the Honorable Philip Golson, Mr. Derek Aikman, Sam Rayburn, and a few others that broke away and formed the NABR. Now, that fracture would eventually join forces with the United Democratic Party in the 1993 elections. They would join back as a coalition government, if you would recall, because it was promised to Mr. Golson, according to Mr. Esquivel, that they would repeal the Maritime Areas Act. So this Maritime Areas Act, the reducing our claim from 12 miles, it wasn't actually reducing our claim, but rather a good faith gesture by Belize to allow Guatemala that access.
I think you put it so clearly, because one of the things, this takes a lot of, we need to understand how it works, the laws of the sea specifically. And I recall looking back in the archives at the story, and it was absolutely a divisive issue. While there was bipartisan support, there were some people who felt that we were giving up part of our own territory, or insular territories, that is. And the campaign of the peace rally and that entire movement in trying to get people to understand that this was a move towards peace was one that was very active. And so the bill was passed, and now we have the Maritime Areas Act. And I want to talk about what's going to happen today, just to put it into context. You've seen the proposed bill.
Yes.
And you know exactly what direction it is going. Let's talk a bit about that.
Yes. Okay. So like I mentioned before, the essence of this bill, it is very short.
Yes.
It is an amendment to the 1992 Maritime Areas Act. And what it is in effect doing, and the operative clause here is going to be clause 3 of the Maritime Areas Act, because that is actually the clause which states that as a matter of good faith on the part of Belize, we would be reducing the 12 mile to 3 miles to allow you access to the high seas. Now the fact that we are no longer in peace talks, it doesn't necessarily mean we're at war. The opposite of peace in this instance is not war, but Guatemala must understand that it is important, if Belize is going to a court of law with you, we must maintain all our legal rights. And our legal rights, according to international law, says that we must claim the full 12 nautical miles. And so here we have, this is the original Maritime Areas Act. And if we can go to 12 nautical miles, if we can go down a little. Sorry, here it is, sorry. Subject to subsection 3 below, the territorial sea of Belize from the mouth of the Sarstoon to Ranguana Key. So it wasn't the entire baseline of Belize that we're saying we're going to reduce the 12 miles to 3 miles. It is only from the mouth of the Sarstoon to Ranguana Key, because then that would allow Guatemala sufficient access to the high seas. They didn't need the entire baseline. So from the mouth of the Sarstoon River to Ranguana Key comprises those areas of the sea having as their inner limits the baseline of the territorial sea as measured from the features listed in the schedule to this act, and as their outer limits a line measured seaward from the baseline, every point of which is 3 nautical miles from the nearest point of that baseline. So here it is, the operative clause, which is actually reducing the act of good faith by Belize in these peace talks, because we are in peaceful negotiations with Guatemala, is to reduce our claim from 12 to 3 miles, but only temporarily and in light of a pending possible settlement. And here we go, and we make it very clear here. Yes, we make it very clear here that we are not giving up our claim to 12 miles. For the avoidance of doubt, it is hereby declared that the purpose of the limitation of the territorial sea from the mouth of the Sarstoon to Ranguana Key, as described in subsection 2 above, is to provide a framework for the negotiation of a definitive agreement on territorial differences with the Republic of Guatemala. Now, when you look at this section, what does it remind you of? It reminds you of the Referendum Act, which says that when we have a settlement, we're going to take that to the Belizean people for a decision. That is what this is saying. And so the two are in agreement with each other. They coincide with each other. And so if you recall, when the Prime Minister originally sent the letter to the Governor General, it was for a proposed settlement of the Guatemala issue. So it was pursuant to this, which, as we now know, was not the proper method to have gone to a referendum, and it was later rectified. But here we have a situation where, and if we go to 3B, this actually speaks to taking the matter to a referendum. Any such agreement, as is referred to in A above, shall be put to a referendum by the electors for their approval or otherwise, and if approved by a majority vote, shall form the basis for the final delimitation of the territorial sea in the area of the sea from the mouth of Sarstoon to Ranguana Key. So here we have it. Back then, we were all for peace, we were all for negotiation.
And there seemed to be a possibility of a settlement.
And there seemed to be a possibility of a settlement at that time. 1992, 27 years ago.
A lot has happened
you guys might not have been born as yet.
I'm not that young.
I'd like to believe that. Yeah.
Yes. So here we are now, 2019, some 27 years later.
Yeah.
We have already decided as a country that we are not going to have any opportunity for a peaceful settlement of this issue. We are going to the ICJ, and if we are going to the ICJ, we must claim our full 12 miles of territorial sea, and that is the importance of today.
Yes.
And that is why we have a bipartisan approach going into today, where both sides of the House, the government and the opposition, will be holding hands on this, because this is something that was very important for the People's United Party even before going to the referendum.
It was a part of your declaration.
Yes, the People's Declaration, that we had to amend the Maritime Areas Act. And so, in my opinion, it is better late than never. If you recall, in December of 2017, Senator Amon Courtney actually put a motion in the Senate to have the identical amendment made. So this is nothing new. We have been clamoring for this from 2017 because we realized the importance moving forward. If we are to go to court, we must claim the full 12 miles.
And that's where I'd like you to put on your legal hat for a second here to kind of explain why this move is essential before we embark on the legal process itself.
Yes, because if it is, Marlene, that we are going to go to the ICJ, and I'm absolutely certain that our international lawyers have been clamoring for this amendment as well.
Yes.
Because if it is that we are going to go to the ICJ and we did not amend our Maritime Areas Act, it would certainly have worked against us, because the court would have said, listen, you have in place a law that says you are restricting your claim from 12 miles to 3 miles, and you seem to be in acceptance of this. You seem to be fine with this. That seems to be the lay of the land, the status quo, and it seems that you're willing to concede to Guatemala that you don't want your full 12 miles. Now, back in the day, I think it was before we gained our independence, Britain had a similar arrangement with Guatemala, in relation to that access to the high seas. And so that was what President Elias Serrano was insisting on. Listen, let us go back to the days where we had it with the British, that we would have that access to the high seas. And so that, again, is a factor that we have to consider, that when we were under British rule, they allowed Guatemala that access. And so President Serrano, who was a close friend of Belize, was saying, let us still have that. But no, moving forward, as an independent country, and as talks have broken down between the two countries, it is absolutely important from a legal perspective that we stand on the strongest possible footing moving forward, and must claim all our legal rights, including that 12 miles. So I think the international lawyers are insisting on it, and I'm glad to see that the Prime Minister is making that move today. Let
me ask a question in terms of what it means on the ground. Now, if we get the map back up, it's going to help us too. After this amendment is passed, the access that was allowed for Guatemala to be able to use is no longer available to them. So what does that mean?
You know, I don't like to speculate, but
so here we have it. So if we exercise our full rights for 12 miles, which is around here, the Belize-Honduras median, the Belize-Guatemala median.
Correct.
They no longer have access out.
That is correct. And so it is likely that this move by Belize, which is the proper and right thing to do, will upset the Guatemalans. It will agitate the Guatemalans, no doubt. And so I think we as a country and we as a government, we need to be prepared.
Yes.
Whether it is that we garner the support of our international friends to come in and give us support in our Coast Guard and the monitoring of this particular area, because I suspect, I don't want to speculate like I said, but I suspect that it will agitate them and may lead them to do things that are unneighborly. they may become more aggressive with Belize. And so we as a country, we need to be prepared for that. But they must respect and they must understand, Isani and Marlene, that it is essential for Belize to make this move when it comes to amending the Maritime Areas Act, because in international law, that's what we're entitled to. And so if it is that the Sarsoon is ours, which we have always maintained, then we must go out 12 miles. That is what international law says. It's not 3 miles. Nowhere international law says 3 miles. We must claim 12 nautical miles. And so while Guatemala must understand that, while the international community understands that, it will no doubt upset them because they are now sort of sea-locked. Not landlocked, but sea-locked, because they no longer have that unimpeded access.
And to be clear about it, because we haven't really mentioned it, it's also because of the proximity of Honduras.
Correct.
And there's also a factor in terms of the amount of coastline that you have as well.
Correct.
And looking, I asked that question because I think if we consider what this amendment will do, I wonder what the next move will be from Guatemala. Perhaps they will understand that this is a part of going to the court. But quite a number in looking forward to the ICJ and looking over the legal opinions and some of the articles that spoke specifically about this area. This was always going to be an issue that was probably going to end up at court. Whether the International Court of Justice or the UN Convention on the Law of the Seas. Can you explain why? Is it that they should have access as an independent country? Is that what it is?
Well, it conflicts. Because according to international law, we are to claim 12 miles from each of our respective countries. But because of the way that the countries are laid out, so to speak, if you look at it, Honduras claiming it's 12 miles, Guatemala, it's 12 miles, Belize, it's 12 miles, then you have an issue because they cross-cut each other. And it is that cross-cutting of each other that causes a problem that needs to be resolved. Now, what the law says, international law, is that you are to claim up to your equidistance. That is important. The middle line between the 2 points. So we might not be able to get 12 miles, we might be able to get 6. Guatemala gets 6 or Honduras gets 6. They make cross-cut. And so it is drawing that line, that imaginary line in the water that all the parties are supposed to respect. That is the issue that we're facing right now. Where is it that the boundaries in the sea actually lie? And will it result in either country getting one of our islands or something like that? Because like you rightly said, Honduras now comes into the picture. And no doubt I believe that they will have a role to play moving forward at the ICJ.
In the context of the overall dispute, isn't this an integral part of the claim? The fact
Absolutely.
the fact that Guatemala is sea-locked, it would need Belize to be able to access the Caribbean Sea.
Hence, if you go back, this issue goes all the way back to the 1859 treaty. And they rightly recognized that they were landlocked, but the law doesn't protect them. And so they included it as part of the treaty that, listen, we're going to have a cart road because we need to access the sea. We're going to have access to the rivers. It actually says we're going to employ the rivers for the purposes of commercial use. And so those things are included in the 1859 treaty. And no doubt it will form a part of the legal challenge by Guatemala moving forward to say, listen, hey guys, we had that provision in the 1859 treaty, and so there needs to be some accommodation made for us. Again, Belize recognized that because in 1992, we actually reduced from 12 to 3. But now we're no longer talking peace, we're now actually going to a court of law. And in a court of law, the law will prevail. So that is what we as a country will be relying on.
Let's go back a bit. We're now looking at a bipartisan effort moving forward, which is to be commended. But I can't help but sit here and wonder why this didn't take place from the beginning and why didn't it stay the course? So even if we're saying that it began as a bipartisan effort, and then at some point we divorced and moved in our separate directions, why didn't we stay the course? Because this is worth every ounce, every aspect of it.
I fully agree with you, and I fully endorse that position, Isani. Under the People's United Party from 1992, as I mentioned, when the Maritime Areas issue came up, everybody as a country was united when it came to Guatemala. And that should never have, we should never have broken that path. That was the case leading up to 2008. the signing of the special agreement, despite the signing of the special agreement not being taken to the House of Representatives for approval, the People's United Party stayed engaged all the way up until 2016. And at that point, I believe we became very discouraged by the path which we were taken down by the foreign minister, the Honorable Sede Elrington, because there was a meeting in Istanbul, if you could recall correctly, where the issues came up as to the Sarstoon Protocol. And that has been something that has been the subject of much discontent within the People's United Party, because we feel as though the government was not fighting for the Sarstoon. And at that meeting in Istanbul, nothing came of it. And so we became very discouraged. And the government from that point on never reached out to us. And I believe it was Asad Schumann who said it on the Krem radio show. He said that it is the responsibility of the government of the day to reach out to the opposition and to ensure that that bipartisan effort continues. All that said and done, we are now going to the ICJ, and it is absolutely imperative that we hold hands on this issue. And so I'm glad to see that the weapons have been put down, not only from the government, but from the opposition, and to see that we now have representatives on this bipartisan commission in the form of Senator Amon Courtney and Leslie Mendes, who is a great attorney at law, young attorney at law. I love the representatives that we have chosen. So I am happy to see that we are now united as a country moving forward.
You know, you've been an integral part of this process in putting together, and especially some of the major issues that came up in the past year, looking at the legal opinion that fed into the challenges within the courts. You also, I know, are very well aware of the Southern and Western Caucasus' very strong stance from the start of not going to the ICJ. Having been privy to those conversations, talk to me a bit about the change in position from those who held the strongest no position.
Well, they still very much believe in their strong no position, and we have to respect that, Marlene, and that's something that I have always maintained throughout my campaign on this issue, is that we must be respectful of other Belizeans. Some actually have a lot more to lose than others. Those in the southern portion of our country, the Punta Gorda, in Toledo West, they have a lot to lose, and so we must respect that. We must respect their opinion. Out in the West, we saw a powerhouse in the form of the Honorable Erwin Contreras losing the yes vote. Who could have thought that? But those people who live in Benque, they know how Guatemalans aggress them, and they know the threat that Guatemala poses to them. And so we must be respectful of that moving forward. So that has always been my position. Whether you are yes or no to the ICJ, let us be respectful of each other's opinions on this issue.
And following up on that, we saw in an interview with the leader of the opposition on Friday, where he was asked about potentially withdrawing the claim in the court. Your legal opinion was really what fed the claim itself. How do you feel about potentially having gone this far in the process and withdrawing?
You know, I am in a very peculiar position, Marlene, because yes, I was one of the lead attorneys along with Mr. Sylvester and Mr. Bradley, who originally put forward the legal opinion. And I've had a long discussion with Anthony Sylvester, because we're both very committed to our legal opinion, and we're both very convicted in how we feel about the settlement agreement. But he understands my position as well, because I have a dual role to play. I am not just an attorney. I am also an area representative of the people of Caribbean Shores. And the people of Caribbean Shores can tell you that I did not ask a single one of them to vote no. I did not ask a single one of them to vote yes to the ICJ. I totally left that up to them. You see, we're a unique, independent-minded voter in Caribbean Shores, and so I must respect that. This is a national issue that has a lot of passion, a lot of emotion. Everybody feels strongly in their position, and that was no place for me to try to impose my views on them. And so moving forward, I must respect them as the area representative. And so while I see absolutely great merit in the legal challenge, I must understand that I am not here as Kareem Musa. I am here as representative of the people of Caribbean Shores, and they have spoken. And if they're saying that we are fine with the way the settlement agreement is, who am I to challenge that? I must respect that. And so even going into the referendum, I at all times had to acknowledge and be conscious that I was performing a dual role. As a member of the opposition, I had to hold the government's feet to the fire to ensure that all their T's were crossed, all their I's were dotted, and we had our ducks in a row. That was my role. I can't see the people of Caribbean Shores actually saying, wow, Kareem just agree with everything the government is saying, and laying down and allowing them to have their way and have this one-sided campaign. No, they love the fact that I put up a fight, but at the same time, they made up their own minds, and I did not influence them one way or the other. And that is how it ought to be. So moving forward,
So what I hear from you is that you're respecting, based on the outcome of the referendum, although you still hold on to what was put forward in the legal opinion, which fed into the claim itself.
Correct.
Because there was a lot of talk about rule of law, which is still a substantial issue.
You see, what it would have come down to, Marlene, at the end of the day, was what we're asking for. Yeah. Let us take the settlement agreement to the House of Representatives for a 2/3 vote. Now, put me in the House of Representatives after a yes vote in my division, and I'm going to go no? I cannot. I cannot. It will be foolhardy. My hands are tied because my people have spoken. And so the government, in my opinion, would easily get a 2/3 majority on the settlement agreement in the House of Representatives. And so that is why I'm saying it is, from this point forward, pointless for me to be engaged in a legal battle, and I fully support my brother Anthony Sylvester, fully support Mr. Courtney if that's the wish of the majority of the claimants. I don't get that idea. I think it is that we are going to withdraw the case. That's what that's the indication I'm getting. But certainly me moving forward, I cannot move forward on a legal case knowing that I have that role to play as an area representative, and my people have spoken on that issue.
You're basically in a catch-22.
Yes.
But you said something so clearly just now in terms of the people of Caribbean Shores being happy that you are holding the government accountable. One of the biggest criticisms about the claim when it was brought forward was it was 10 years after the signing of the special agreement. And looking at the bipartisan approach moving forward, I think there are clearly some lessons to be learned here about ensuring that people are adequately informed of the steps being taken and the proper mechanisms are being followed. Is that a commitment that you now have moving forward, understanding that decade-long delay that took place with the challenge for the special agreement?
Well, going back to that issue, like I said, the Senator Amon Courtney had raised it from 2008. The Prime Minister had made a commitment on national TV that he was going to take it to the House of Representatives. And so any move by any attorney to say, hey, you didn't take it to the House of Representatives would have been premature. So it's not that we were late. It was actually at the perfect moment that the legal challenge was made, because you had to afford the government that opportunity to take it to the House. They could have taken it any time within that 10-year period, and they chose not to. And so that is why the legal challenge was launched at that final hour, because the government did not act. So that clears up that point.
Okay. Now I want to bring it back to the Maritime Areas Act for one more question before we move forward. One of the questions I think that remains in people's minds is, what will this mean for the Sarstoon, where we have seen the continued aggression by the Guatemalan military? And I want us to be absolutely clear, because when we talk about declaring or full 12 territorial miles, I think people may be of the assumption that it addresses the issue in the Sarstoon. Is that the case?
It does not address the issue in the Sarstoon, not at all, because the territory that they are actually aggressing us is not even 3 miles out. It's actually right within 1 mile. It's actually the Sarstoon Island that they are saying this is ours, which the 1859 treaty does not give them. That the 1859 treaty very clearly states that your boundary starts at the southern portion of the Sarstoon in the middle of the river, and so their claim to the Sarstoon is totally unfounded. Where I would want to see our government moving forward, it doesn't mean that because we're changing the Maritime Areas Act today, means that our job is done. We continue to face aggressions in the Sarsoon on a daily basis. And so what I would want to see moving forward is involvement from the OAS to voice their concerns, to support Belize and saying, listen guys, you have no right to be on Belize's side of the territory based on the 1859 treaty. And I want to see our protest notes published. I want to see, as a member of the opposition, I want to be privy to see what it is that our government is saying about these aggressions in the Sarsoon, and if necessary, for us to invoke Article 39 of the UN Charter, which says that no country should aggress another country, and especially now that both parties have peacefully agreed to go to the ICJ. There should be no aggression moving forward. And so that's where I'd want to see us moving forward on this Sarsoon issue.
Well, the current commitment by the government, as been mentioned quite a few times, is to look into a provisional measure at the International Court of Justice.
Yes, and I fully support
once
that.
the case has been filed.
And I fully support that, yes.
And do you have hopes that that will help to solve the issue?
Absolutely, because what it would mean at a very interim level, before we even get to the ICJ, is a declaration that under the 1859 Treaty Guatemala, you have no right to be doing what you're doing. So on a very interim level, it would set the stage for a victory for the government of Belize and for the Belizean people at the ICJ. So I would do that if I were the government of Belize.
All right. So undoubtedly today at the House, we can preempt what the results will be?
Barring any unforeseen changes, if what they shared with us is what they're taking to the House of Representatives, you can expect unanimous support from the House of Representatives, something that is very rare.
Yes.
No doubt. I think the last time was the 10 grams issue. I think we were united on that one. So it's not, it's rare and it's not common, but certainly moving forward.
That's an interesting reflection on the matters of importance in this country.
It won't be a fiery discourse.
Absolutely not. It should take less than half an hour.
Okay. But before we leave, before you leave, I should say, I would hate to not have the opportunity to talk to you about what's happening within your own constituency. We know that there are currently 3 potential candidates that may be going up in the Caribbean Shores area. I want to get your reflections on that.
Well, for a moment there, I thought they were going to leave me unopposed going into the next general elections. It's certainly, if not the last division that they have a standard bearer in, one of the last. I think Fort George might be the only other one that they don't have a candidate. I wish them all the best. I have to be quite honest here in saying that I believe Darrell Bradley was by far the most formidable candidate for the United Democratic Party. But from what I'm hearing, he has now been sidelined, and it's now a 3-candidate race with Mr. Castillo, with Mr. Chang, and Ms. Perfit. So I wish them all the best, no doubt, moving forward. But if you're going to ask me who I prefer, I'm just glad it's not Darrell. Darrell was by far the best candidate. These are all individuals who have had an opportunity in electoral politics. I won't say that they have failed, but some of them have had their opportunity. In Caribbean, I don't like to speak badly about my opponents, but if you listen to what the people of Caribbean Shores are saying, they're saying that you had a shot, you missed the shot, and now it's time to get off of the pot. You had that opportunity already, and you lost it.
In the case of Santiago, he won. And
yes, but it's not about winning, Isani, and that's the issue, because I heard him say that in his interview. He said that Caribbean Shores is like a bicycle. You just have to jump back on it and ride, and the people will love you. That is not the case. This bicycle is a 2020 bicycle, you know. It has memory. It doesn't have amnesia. It has a computer memory.
A built-in chip.
Yes, a built-in chip that has a good memory. It's very recent. It's not as though this took place 20 years ago. And so he did a Houdini on the division and disappeared after winning in 2012. And so he was very unfair, in my opinion, to his successor, Darrell Bradley, in saying that Darrell lost 700 votes, the turnaround. I think that he lost that. And Darrell was actually there trying to save him, because the United Democratic Party had lost terrible ground while Santi was in office. It's not common for somebody to win and then to be benched like that, the way Santi was. The reason he was benched was because he went missing. So
no preferred candidate?
It doesn't matter to me, really. At the end of the day, what I have done in my division speaks for itself over the last 4 years. I think the people are very appreciative of the voice that I offer, especially in the House of Representatives. They know that moving forward, they have a strong voice. They know that they have someone with a vision for Caribbean shores. And so I'm comforted by that, but at the same time, I know that I have to continue my work. I'm not going to take any of them lightly moving forward. I must continue the work in Caribbean shores. And once again, I am confident that my team and I will rise to the occasion, and the people of Caribbean shores know that when I rise, they rise.
All right. Well, it's not very long that we'll have to wait to see what happens there. Yes. So thank you very much for coming in and sharing your perspective on this issue, but more importantly, talking about the Maritime Areas Act and the amendment that will be introduced today.
Thank you very much, guys.
We're going to go ahead and take a break, and when we come back, we'll be shifting to talk about gill nets. So stay tuned.